In this lecture, we're going to be talking about legal issues with a focus on legal issues related to psychiatric nursing. In some of your previous courses, you should have already discussed legal issues such as patient privacy, confidentiality, and HIPAA compliance. All of those things still apply in psychiatric nursing. However, there are some specific legal issues that we need to cover regarding this patient population. As always, I have the objectives for the lecture listed here, and you should use these objectives to guide your studying and preparation for the exam.
While legal issues are important for the general fundamental purpose of abiding by the rules of the law, we discuss legal issues specifically in psychiatric nursing because, sadly, people with mental disorders are often mistreated, and they're often treated in manners that you would never think of treating other patients. Therefore, as the nurse, you hold an ethical responsibility to be advocates for your patients. You are legally accountable for the care that you provide. And under the Nursing Code of Ethics, you are required to provide ethical care to all of your patients. Sometimes this gets a little bit tricky because the role of the government is to balance the rights of the individual and the rights of society. And we're going to talk in this lecture about what happens when we need to violate rights of the individual, such as putting somebody in restraints, sharing information that they provided to us in confidence so that we can protect the broader public. My best information to you regarding these types of issues is to know the policies at the facility where you work. I will tell you reading policies is very boring and tedious. However, if you just glance over those policies and sign your name that you have read and understood them, you have still signed that you read and understood them. And in a court of law, if you violate a policy, it is not going to hold up to say that you did not read the policy in detail. Make sure you know the Nurse Practice Act, which is the standard that you will be held to as a nurse, as well as the policies at your facility. And I'm not saying know this for an exam. I am saying know this for life in your professional life as a nurse. As I develop this lecture, I am basing this lecture on the assumption that the vast majority of the class does not have a broad or deep understanding of the law. Therefore, we are going to begin with a brief overview of the law and the legal system through the framework of how does it apply to us as nurses. Torts apply to nursing because they're related to acts or failure to act that causes injury to another individual. And as nurses, our actions or our failure to act can actually cause injury to another individual. So what you need to be aware of as a nurse is the reasonable standard of care. And the idea behind the reasonable standard of care is that as a nurse, you need to demonstrate professional judgment and act within the scope of practice of a registered nurse. You need to be familiar with the scope of practice in the state where you are working in. The Nurse Practice Act varies by state. I do have a link here for the Pennsylvania Nurse Practice Act, and you would want to look at section 21.11, general functions, to know what is the expectations of you as a registered nurse in the state of Pennsylvania. As a nurse, you have a duty to care. You took a job for the hospital or healthcare system where you choose to work. You therefore have a duty to provide safe and effective care within your scope of practice to provide that reasonable care to patients. A breach of duty occurs when you fail to provide that reasonable standard of care to an individual, when you fail to provide the care that any rational nurse with your level of training as a registered nurse, would provide to that patient in that situation. This concept is especially important regarding negligence. Negligence is a failure to do or failure to not do what a reasonable person with the same level of training would do under the circumstances. For negligence to occur, you must be able to prove that all four elements happened. This is very important. Negligence is not just a breach of duty. So we're going to talk about this. First off, there needs to be a duty to care. Did you have a duty to care? Were you in your role as a registered nurse at the healthcare system and had a duty to care for people? If you did not have a duty to provide care, then failing to provide care is not negligence. And I want to say that with a caveat, because there are some states where if you are out in public as a registered nurse and you see somebody fall or go into respiratory or cardiac arrest or have any other type of injury and you don't respond, you still have a duty to care. Know what the regulations are in your state. Beyond a duty to care, did you provide the reasonable standard of care? Did you provide the care that a prudent nurse would be expected to provide in this situation based on the knowledge available? If you answer no to that question, then you have breached your duty to care. Either you chose not to provide care that was reasonable, or you provided different care than the care that was reasonable. This becomes negligence if your breach of care causes injury to the patient. And that's really the key here, is we're looking at the outcome. What happened to the patient as a result of your acts? When we are referring to negligence in the professional setting as a nurse, we call this malpractice. Malpractice is most simply put professional negligence. You had a duty to provide care, you did not provide the reasonable care, and somebody got injured because of your professional role. Often, malpractice occurs because the nurse fails to prevent harm or fails to maintain the standard of care. And I have a picture here that has the 4 Ds of malpractice. It's the same thing as the 4 elements I spoke of on the last slide, but for some of you, this might be easier to understand because of the similar letters. You have a duty to provide care. Did you deviate from the standard of care? And was your choice to deviate from the standard of care the direct causation of the damages that the patient experienced? Your employer is responsible for your acts only to the degree with when you are acting within the scope and authority of your employment. So that means your employer is only going to take responsibility for your acts if you are following the institution's policies and procedures, and if you are acting within the scope of practice of a nurse. And this is what's called the master-servant role. The master is only going to take responsibility for the acts of the servant, the organization taking responsibility for your acts as a nurse, if you are acting within your scope of practice. The best way to prevent malpractice besides knowing policies and procedures at your organization, and besides being aware with the nursing scope of practice, is to follow evidence-based practice. To give you some examples of common malpractice suits, we often see malpractice regarded to lack of care with confidential information, leaking confidential information that can result in harm to the patient, illegally confining a patient, resulting in harm, failure to obtain consent for treatment, which then causes harm, and we're going to talk about that on the next slide a little more. We're now going to talk about two other torts, assault and battery. It is very important that you understand the difference between assault and battery. I often hear these two terms used interchangeably. However, they are not the same thing. And for proper documentation as a nurse, you need to understand the difference. Assault is a deliberate threat to harm another with the ability to follow through and harm that person. An example of assault would be verbally threatening a patient that you are going to force them to take their medication against their will. Battery is when you intentionally cause that harm, when you touch another person in a socially impermissible manner. So assault is threatening to force the patient to take their medication. When you take actions and you either inject that patient or you give them that IV or you put that medication in their mouth, now you have committed battery. Another very important legal consideration for nurses is the duty to warn, which is often referred to as the Tarasoff rule. And this duty to warn came about in 1976 after Tatiana Tarasoff was killed by an ex-boyfriend. I do have a link here to the Tarasoff versus Residents of the University of California case. It's about 2 minutes in length. It's a brief YouTube video that discusses this case where Tatiana's broke up with her boyfriend. Her boyfriend told his therapist that he had intent to kill Tatiana and a plan to kill her. The therapist did not report this to Tatiana or her parents, and the boyfriend was released from a psychiatric hospital because he did not appear to be a threat, and he stated that he was no longer going to kill Tatiana. He then showed up at her residence and killed her. This case went all the way to the Supreme Court, and the outcome is that you must notify, as a healthcare clinician, the police or the potential victim in an attempt to prevent harm if an individual tells you specifically who they intend to harm. So if somebody just says very vaguely, I just want to kill people, you don't know who to inform. If they tell you they have a plan to harm a specific person or a specific location, say that they want to blow up Messiah University, you must report that. The patient no longer has the right to confidentiality under HIPAA because other individuals' lives are at stake. This is very important, and I would make sure you watch this video, you understand what the duty to warn is, because you may have to enact it at some point in your career. We're now going to look at a brief case study to help us review what we learned about law. Andrew was admitted to an inpatient behavioral health unit last night due to having thoughts of killing his boss. Andrew works in a high-pressure environment. He had a knife when he arrived at the emergency department and had intended to use it. His 5-year-old son had walked into his room prior to his leaving the house and asked why he had a knife. Andrew came to the emergency department to seek help to prevent harming his boss. Which of the following laws most applies to Andrew's situation? A. HIPAA confidentiality. B. The Tarasoff rule. C. Negligence. Or D. Battery. I would encourage you now to pause this recording and think about your answer. The answer to the question is B. The Tarasoff rule. Andrew has voiced a desire to harm a specific individual. He has the means to harm this individual. And he has given specific means for how he plans to harm the individual with a knife. Therefore, this initiates the duty to warn, the Tarasoff rule, and either the police or Andrew's boss need to be notified. This is not a case of HIPAA confidentiality, specifically because the boss's life is at risk. This is not a case of negligence. There is nothing at this point that would make us believe that the nurse or the doctor have breached any duty to care or that harm has come to anybody. This is also not a case of battery. Andrew has not inflicted harm upon his boss at this time. Now that we have talked briefly about the law and about your legal responsibilities as a nurse under the law, we're going to shift the focus now to the rights of patients and what legal and moral rights do patients have, and more importantly, how do we protect and uphold those rights as nurses? When we look at protecting the rights of patients, we look at this concept of self-determinism, or the right that a patient has to consent to treatment or refuse treatment. All patients have the right to say yes or no to wanting treatment unless there are some specific instances, such as when the patient is deemed a threat to themselves or a threat to others. And this is because the patient is deemed to not have the capacity or the ability to make an informed decision, or to make a decision that would be the decision that a logical, rational person would make at that time. Because it is considered, if you are a threat to yourself or your others, you are not thinking logically and rationally. So therefore, we have to balance the rights of the individual to protect the individual and to protect others. The term capacity looks at your ability to make an informed decision. Do you have this ability? And we determine if you have this ability by looking at competence. Competence is a legal determination. We do not make the determination of competence as a nurse. Competence is the ability to communicate the choices that are available, to understand the information relevant to the situation, including everything that is going to occur and the consequences, everything needed to provide informed consent, the ability to compare the risks versus benefits, the decision of competency for a patient, an overall generalized competency for a patient, is determined by the court. So a patient is competent until they are deemed otherwise by the courts. Just like legally you are innocent until proven guilty, you are competent until you are proven incompetent. Now, a patient may still be competent, deemed competent by the law, but due to a specific situation, such as being under the influence of drugs or alcohol, or having just come out of surgery, we as nurses can say that the patient does not have the capacity to make an informed decision at this point in time. Very important. The courts determine overall competence. You as a nurse can determine capacity for individual situations. Some of you may be familiar with the term the Patient's Bill of Rights. The Patient's Bill of Rights has recently been replaced by the American Hospital Association with the Patient Care Partnership. And the idea of the Patient Care Partnership is that this provides the patient with an overview of what they are to expect during their hospital stay. They are to expect high quality care, that the staff are going to act within their scope of practice and provide the standard level of care to the patient. They should expect that the environment will be clean and will be safe for them. They should expect that they will be involved in their care as an active member and decision maker in the care team. They should expect that their privacy and confidentiality will be protected to the extent allowed by law. They should expect that they will receive help such as discharge planning, discharge instruction, follow-up upon leaving the hospital, and they should expect that they will be provided with help and support regarding bills and billing claims. I do have a link here to the American Hospital Association Patient Care Partnership, which explains all of these expectations in a little more detail. The other important thing about this partnership, beyond protecting the rights of patients, is that these expectations need to be followed by the healthcare system so that Medicare and Medicaid programs reimburse the system. We're now going to specifically talk about the treatment and patient rights in psychiatric nursing. And the important thing to understand about the treatment of patients in psychiatric nursing is that the treatment that was provided at any given time in history was often deemed and viewed at that time as the most humane way to treat patients that were a harm to themselves or a harm to others. The picture on this slide is a picture of the tranquilizing chair from the 1800s, and it actually came from the archives of the University of Pennsylvania. And at the time, in the 1800s, this chair was deemed humane, and in that it was a way to calm the humors or the liquids in the body in an attempt to improve the madness within a person. And if you are somebody who is very interested in history, I would encourage you to click on the link at the bottom of the slide. You can learn more about the tranquilizing chair. So, at this point in time in history, when we are looking at the treatment and patient rights in the inpatient setting, we are thinking of things such as the suspension of rights, the suspension of privileges to have your phone, the suspension of the privilege to wear your own clothes. These suspensions of privileges are done with the intent of keeping the patient safe. We also look at providing the least restrictive environment, which means using seclusion and restraints as a last resort to keep the patient safe. Trying things such as behavioral therapy, communication, therapeutic communication, even going to things such as medication to restrain a patient before physically restraining a patient, and then before having to seclude a patient, because we want to keep the patient safe, but we don't want to inflict extra harm on the patient. And there's this concept of false imprisonment. False imprisonment can be using excessive force to restrain or seclude a patient without the appropriate documentation for why restraint or seclusion needed, or using force that is beyond what is necessary or rational to be able to restrain or seclude a patient who does need restraint or seclusion. Preventing a patient from leaving who has the right to leave the facility and has not been deemed incompetent to make decisions about leaving, or wrongfully committing a patient to a psychiatric facility. I now want to take a little bit of time to focus on restraints and seclusion. I could spend an entire lecture discussing restraints and seclusion. I spend a lot of time doing education in the ER where I work on restraints and seclusion and when they should be used, when they should not be used, appropriate documentation. However, I'm going to keep this as general as possible, and I'm going to tell you you need to refer to your facility for more specific information once you get your job. So, with restraints and seclusion, they are a last resort. You need to be able to document that you have attempted other interventions before restraints or seclusion were used. A physician's order is required within 1 hour of putting restraints on a patient, and what we call these violent restraints. Within 1 hour of restraining a patient for their safety, you need an order from a physician. This order needs to include the type of restraint used. Were they soft restraints? Were they hard restraints? Were they 4-point restraints, 1 on each limb? Were they 2 points? Were they 3-point restraints? What is the rationale for the restraints? And what is the time limitation for the restraints? Very, very, very important. I cannot say this enough. PRN orders for restraints and seclusion are not permitted. You cannot have a doctor put in an order for restraints as needed. This is not to say that you will not see this. Sadly, you will see it at some facilities. Do not use a PRN order for restraints. Call and get a specific order for that episode. Documentation is essential if you are using restraints or seclusion. Frequent documentation is necessary because this is a high-risk situation, and your documentation is what is going to make sure that you are able to demonstrate that you were acting within your scope of practice and within the law. You need to clearly document the interventions and the events that led up to restraints. So you need to document all of the less restrictive interventions you tried. You need to document what happened that made the decision occur that restraints needed to be put in place, and so that you can clearly justify the use of restraints. While a patient is in restraints, they need to be under constant observation. They do not need to be under observation constantly by the nurse. Some of you are patient sitters and you are very intimately familiar with this, but somebody needs to be observing them at all time. The patient also needs to be informed of what behaviors are expected for them to be released from restraints. It is inhumane to put somebody in restraints without telling them what they need to do to get out of restraints. People should be in restraints for the shortest amount of time possible. And this is very, very important. If the patient is asleep, they should not be restrained. They are not a harm to themselves or to others while they are sleeping. So, you need to be able to justify why they are in restraints. Documentation. You need to document every 15 minutes comfort interventions. The 15-minute documentation can be done at some facilities by a nurse or a tech or a sitter. You need to find out at your facility what the rules are. Every 2 hours, you must document as a nurse the continued need for the restraints, the ongoing need. After the restraints are removed, you need to debrief with the patient and document that you debriefed. This debrief is going to help discuss what led up to the restraints and help the patient discuss coping mechanisms and alternate responses so that hopefully restraints do not occur again. If a patient is removed from restraints and needs to be re-restrained, you need a new order for this. Patients may request that you notify a friend or a family member that they have been put in restraints. They have a right to do that, and you should notify that friend or family member. Anytime a patient who is restrained dies while they are restrained, this must be reported to the FDA. Again, very important. You must report any death of a patient that is currently restrained to the FDA. We're now going to go back to our case study with Andrew and look at another practice question to kind of bring back together what we have learned thus far. The unit secretary sees Andrew pacing the unit and appearing agitated. The secretary decides to suggest that Andrew needs to be secluded and calls security to facilitate the seclusion. Which principle of the law is being violated? A, a reasonable standard of care. B, the duty to warn. C, the duty to care. Or D, malpractice. I would encourage you to pause the recording at this time and consider your answer. The answer to this question is D, malpractice. If you recall, malpractice includes the master-servant role, which states that personnel must practice within their clinical boundaries. The unit secretary does not have the legal or clinical ability to assess an agitated patient and determine an intervention, such as seclusion. We're now going to shift gears a little bit, and we're going to talk about patient commitment. And when we say patient commitment in psychiatric nursing, we are talking about commitment to the inpatient psychiatric unit and whether the patient is committed voluntarily or involuntarily. You may have been exposed to some of this information during your time in clinical, but it's important that we make sure that you understand the terminology used. As I alluded to on the previous slide, there are two types of commitment. There's voluntary commitment, which is called a 201, where a patient states that they need help and they choose to willingly go to an inpatient psychiatric facility. There is involuntary commitment, which is a 302, which means that a patient is committed to an inpatient psychiatric facility against their will and based on the hearing of a judge who determines that the patient is not competent to make an informed decision about not needing inpatient psychiatric care. You will find that I do have in the materials for this week a handout that very clearly talks about the levels of voluntary versus involuntary commitment. I have a link to an explanation about Pennsylvania laws for admission on this slide. If you scroll down several paragraphs, you'll see an explanation of both a 201 and a 302 commitment. I also have a link to an article from Life magazine from 1938 about the history of psychiatry and psychiatric commitments. For the exam purposes, we're going to talk about a lot of levels of involuntary commitment beyond a 302. What you need to know for the exam is a 201 and what constitutes or warrants a 201 versus a 302 and what constitutes or warrants a 302. The vast majority of people that you will see in the inpatient unit are there voluntarily. The majority of patients with mental health problems that go inpatient are there because they have sought out help. These individuals usually present to the emergency department. Very rarely do we see direct admission from a therapist's office or a primary care office to an inpatient unit. The vast majority spend time in the emergency department, which is why we have you do a clinical observation in the ER. These individuals, while they are in the ER, sign a consent form to treatment, and most treatments last 48 to 72 hours. And part of signing this consent is saying that an individual understands that they need to give 72 hours notice before they want to be discharged from the facility. That being said, you will find individuals that will sign their 201, and as soon as they get to the facility, they ask for a form to sign to give their 72 hours notice. because they want to know that they can leave as soon as they want to leave. And we'll talk about some reasons why people may get committed voluntarily versus may choose a voluntary commitment when they initially do not want to come into the hospital. And those individuals very often are signing their 72-hour notice instantly upon admission. Patients that come into the inpatient unit involuntarily are coming in because they have been deemed to be a danger to themselves or others. These individuals also usually come through the emergency department, and often they are brought in by the police because either a 302 was petitioned that somebody felt they were a danger to themselves or others, or they were picked up by the police for some type of inappropriate or illegal activity. These individuals may have short-term observation and treatment because they have a treatable disorder that will improve with treatment, or these individuals may need to have prolonged care and a longer commitment. Sometimes a short-term commitment is needed simply because the person stopped taking their medication and ran out, and they just need to be stabilized again. And sometimes there are people that are not going to be able to care for themselves long-term based on their diagnosis, regardless of what level of therapy, interventions, medication we provide to them. We're going to begin by looking specifically at a 201 or voluntary commitment to inpatient psychiatric care. Any individual 14 years or older can voluntarily sign themselves in for inpatient psychiatric care. This is very important to understand. Adolescents 14 years or older can request psychiatric care without us needing to receive consent from a parent. So very important, 14, 15, 16, 17-year-olds do not need parental consent to present to the ER for psychiatric care. Like I mentioned on the previous slide, most patients who voluntarily seek care come in through the ER. There is no hearing required to admit these patients to a psychiatric facility because they are saying they want to go. And through the ER, through the work with crisis and psychiatrists and the emergency room providers, it is deemed that the patient does indeed need inpatient care. If in the state of Pennsylvania, somebody voluntarily commits themselves to go inpatient into the hospital for psychiatric care, the state police do not get notified. This is not the same for an involuntary commitment. Patients must sign a legal document, which is called a 201 form, saying that they are consenting to inpatient treatment. There is no limit on the duration of stay for a patient that voluntarily signs themselves into an inpatient unit. It is not that after X number of days they are automatically kicked out. However, they must give 72 hours notice, which I talked about on the previous slide, before choosing to leave against medical advice. So some individuals, because they do not want the police notified for various reasons, will sign a 201 to go inpatient, and then as soon as they get to the facility, they're signing their 72 hours notice so that they can leave after 72 hours. Some special considerations for minors. Adolescents under the age of 14 can be admitted inpatient by a parent or legal guardian. So if you are under the age of 14, your parent or guardian needs to sign for you that you are getting a 201. So a 14-year-old can come in on their own. A 13-year-old still needs a parent signature. Parents or legal guardians can sign for a child up to the age of 18, even if the child does not want to go to the inpatient unit. If the child is under 18, so if they're between that 14 and 17 years age, and they're saying they don't want to go, but the parent or guardian wants them to go inpatient, and the providers deem it is necessary, and the parent or guardian signs the 201, it is still considered a voluntary commitment. And this occurs in the ER after the providers have again recommended inpatient commitment. In contrast to the voluntary commitment 201 is the involuntary commitment, a 302. Individuals are admitted against their will to an inpatient unit under what is called a 302 because they have been deemed a danger to themselves or others due to their mental illness. A danger to oneself is being able to demonstrate that in the past 30 days, one of the following has applied. The patient is unable to satisfy their needs for nourishment, personal care, or safety that would lead to death within another 30 days. The patient has attempted suicide or committed acts to further their threat of suicide. Committed acts would be things such as going out and buying a gun, going out and buying knives, beginning to hand away all of their personal possessions. Or if the person has mutilated themselves or made acts to further the threat of mutilating themselves. A person is considered a danger to others if it can be demonstrated within the past 30 days that one of the following applies. The patient has inflicted or attempted to inflict serious harm on another, or the patient has threatened serious harm and made acts to further those threats against another. What happens with a 302? If a 302 is petitioned, the individual that is petitioning it must have first-hand knowledge of the dangerous conduct. They must have first-hand knowledge of what makes somebody a danger to themselves or a danger to others. The patient will then be taken to the emergency department either via the police or an ambulance based on the situation. The patient can be held for up to 120 hours against their will as a 302, while further investigation is done to determine the degree of threat to self or others. With regard to involuntary commitment in 302s, for a 302 to be upheld, there must be probable cause that must be found within that 120 hours that a patient can be held in the emergency department. Probable cause indicates that we are able to demonstrate that a person is a danger to themselves, a danger to others, or is gravely disabled to the point that they would not be able to provide the necessary care to perform their ADLs and keep themselves safe and alive for the next 30 days. The Fourth Amendment of the Constitution requires probable cause, as this is a way to protect the rights of individuals from being admitted inpatient against their will. If probable cause exists, the person can be further detained on an inpatient psychiatric unit for observation and treatment as long as that is deemed necessary, which we'll talk about more on the next slide. Patients that are admitted against their will or are brought to the ER against their will under a 302 must be released when no legal basis exists for the continued confinement. So, if there is no probable cause found within that 120 hours, the individual needs to be released. At the point where the individual is deemed to no longer be a threat to themselves or others, they need to be released because at this point it would be considered false imprisonment. If a patient requires treatment against their will beyond the 120 hours of a 302, we begin to look at extended involuntary commitments. This information will not be tested on your exam. However, I do think it's important to go over with you just because you may see a 303, a 304B, or a 305 admission in a patient's chart, and it's helpful to know what these things mean. A 303 is an extended involuntary treatment, and this often occurs, this is the most frequent that you will see, that the patient has exceeded the 120 hours. They are still deemed a threat to themselves or others. So treatment is extended for for up to 20 days. As we continue to go through this process, the patient reaches the 20-day mark and treatment is still needed. Then a psychiatrist must provide testimony to the court as to why the patient needs to be detained longer against their will. This is why your nursing documentation is so important, because the court must be able to deem that extended treatment is necessary. And often nursing notes are a key part of this. A 304B allows a patient to be treatment to be extended up to 90 days. Once 90 days is reached, then again the psychiatrist must go before the judge and have another hearing to indicate why the patient should stay again beyond their will. This can extend up to 180 days. I do not have any extended treatments listed here beyond 180 days, but there are times where longer-term treatment is needed on extended acute care units or at state hospitals for certain patients that are considered to be a risk to themselves or others. While many of you have heard of advanced directives for end of life, you may not have heard advanced directives for psychiatric care. There is such a thing as a psychiatric advance directive, that a patient who is of sound mind and is competent can fill out so that their wishes, for should they be deemed incompetent in the future, that their wishes can be upheld to the extent allowable by law. In a psychiatric advance directive, patients can indicate specific medications that they want used or do not want to be used, including doses and routes. They can indicate treatment options that they would or would not want to be used. A common example of this is the use of ECT. They can indicate behavioral management that they would or would not want to be used on them. And very importantly, they can indicate a list of individuals who should be notified should they be admitted as a psychiatric patient and are unable to make decisions for themselves, and individuals who they would want to be allowed to visit them. They can also indicate what other healthcare providers they have that they would give the inpatient facility permission to make contact with. Often this would be their personal treating psychiatrists, psychologists, family doctors, specialists, therapists. And they can also indicate, should they lose competence, would they want to participate in research studies. And this really allows the patient to have the greatest say in their care. Again, the advance directive would be made at a time when the patient is deemed competent, and then would serve as an indication of the patient's wishes once the patient is no longer competent. To finalize this discussion, we're going to talk about me, the role of the nurse. As the nurse, when you are working with legal issues, you need to prevent the need for restraints or seclusion to the best of your ability. You need to be able to have exhausted all other options before using restraints or seclusion. Thus, you need to provide the patient with the least restrictive environment. And you need to ensure for safety purposes that seclusion or restraints are being observed constantly. You do not accept PRN orders for restraints or seclusion, and you do not coerce or force a patient to accept treatment. As the nurse, you must become good at documentation, because if it is not documented, it is not done. Documentation is what is going to keep you out of court. I will tell you, as a registered nurse with about 10 years of experience, 3 times I've been told I was going to get called into court. 3 times legal for the hospital has come back to me and told me that my nursing notes were sufficient and I did not need to appear in court. It is very important. People can sue in the state of Pennsylvania up to 7 years after the event occurred. Are you going to remember your patient from 7 years ago if all you did was check boxes and never wrote a nursing note?